My name's Michael Manna. I'm an attorney. My office is in Ridgewood on 66 South Maple Avenue. I don't know if anybody has heard of me before, but I'll just tell you a little bit about me. I grew up in Ramsey. I went to Don Bosco High School. Has anyone lived here a long time? And my dad used to own a restaurant on Route 17 in Ramsey. Lake Street was called the Tower of Pizza. It actually had a leaning tower. And I don't know if you remember it, but I washed thousands of dishes there. I didn't even want to go to college. My father said, you don't have to go to college, just stay and wash dishes. So college looked better, so I went to Boston College. I was an accounting major. I graduated in 1970. I was 7th in my class. My mother was very happy. And I went to Boston College Law School, and I graduated in 1973. I was in the top 15%. She was happy again. Then I went to work for a CPA firm known as KPMG. I don't know if anyone's ever heard of it. It's the 3rd largest in the world. I worked in their tax department doing estates and trusts, among other things. And I have left there, and I have been practicing law now in Ridgewood for the last 41 years. I only do elder law and estate planning. I have taught this course to other lawyers for the bar. I've taught it to certified public accountants. I have taught it to social workers. They're all required to have a certain amount of mandatory continuing education every year, and I am authorized to teach them. And I'm a member of the National Academy of Elder Law Attorneys. There's a few over 4,000, only a few over 4,000 in the whole country. So this is what I do. This is all I do, okay? So the one thing I do want to tell you right off the bat is if you need a will done or you need someone that's ill and they're going to go to nursing homes, and I don't know if you've done any checking around, but the average nursing home now runs about $12,000 a month. The better ones are $15,000 to $18,000 a month, so you can go broke very, very quickly. So people seek out elder law attorneys to try to get the government to pay for these programs, and we'll talk about that tonight. And also other things. I find that the elderly get themselves into just an amazing amount of trouble. And I'll tell you just a quick war story. I had a woman come in to see me. She was living out in, she was a Brooklyn resident. And she had 2 nephews. We'll call one the good nephew and one the bad nephew. And she had a $100,000 in a bank account joint with the good nephew and $100,000 in a bank account joint with the bad nephew. And she had a falling out with the bad nephew. He was taking care of her out in Brooklyn. I kind of feel bad for him. He had had enough. He told her that he wanted to put her in assisted living or a nursing home. She didn't want to go. The good nephew who lived here in Bergen County said, don't worry about that. Come and live with me. I'll take care of you. So she decides to live with him. She shows up in my office one day alone. And she said, I want to change my will. I want to disinherit the bad nephew. And I want to leave everything to the good nephew. So I want to tell you, one thing a good lawyer should do, especially if you're doing estate planning, is the first thing you want to know is what do you own and how do you own it? Okay, so I asked her, what do you own and how do you own it? And she said, I have 2 accounts. One's joint, $100,000 with the bad nephew. One's joint, $100,000 with the good nephew. So let me ask you a question. If I have a joint account with this lady at TD Bank, and in my will I say, I give that joint account to TD Bank account number such and such and so to this lady here, and now I die, who gets that account? Okay. How many people think she gets it because she's the surviving joint owner? How many people think she gets it because she is the person I left to in my will? How many people don't think? Okay, well, the answer is that the surviving joint owner always gets what's in a joint account. When you open up a joint account at a bank, it's presumed that on your death, you want whoever it's joint with to get it, okay? Regardless of what it says in your will. Okay, so I told her I could do a new will for you, but unless you get that account out of joint name with the bad nephew, he's going to get it no matter what. So she goes, well, what should I do? I said, well, if you have the passbook, any one joint owner, as long as they have the passbook, can go down and empty that account. They said, what you want to do is get the passbook, go down to the bank, and close that account, open up an account in your name alone. And I must tell you, I am not a fan of joint accounts. I am not a fan of payable on death accounts. People want to do these things because they want to avoid probate. And I will tell you, people think probate is a great Satan, and we'll talk about it later. New Jersey has what's called relaxed informal probate, very, very simple, nothing to be afraid of, okay? But that's why people do these things. So I told her, take the bank book down to the bank, close the account, open one that's in your name alone, no one else's name on it. So when you look at it, you have no idea where it's going to go, and then your will work on it. So she says, okay, fine, she leaves. She calls me up about a week later, and she says, I cannot find the bank book. I think the bad nephew has the book. So I call him up, I leave him a few messages, I finally write him a letter, tell him I'm doing estate planning for your aunt, and do you have her bank book? And he never returns my calls, and finally one day, he must have picked up by accident, I dialed star 67, so we got a blocked number, although today you would probably think I'm trying to sell you something. And I finally got him on the phone, and he said, I don't know what she's talking about, I do not have the book. So now I tell her, he doesn't have the book, and so she says, well, what should I do? I said, well, now you go down to the bank and you tell them you lost the book. They'll have you sign something called a lost passbook affidavit, and they will issue a new book, and then you can close the account with the new book and open up an account in your name alone. So she goes, okay, fine. She goes down to the bank, and the bank gives her this lost passbook affidavit. Unfortunately, it has to be signed and notarized by everybody whose name is on the account. So I now send it to the bad nephew and ask him, would he please sign it, get it notarized, send it back to me. And of course, 2 weeks go by and I hear nothing. And I finally call him and he says, I'm not doing nothing. Okay. Now I'm afraid he's got the book and he may go to the bank and empty the account on his own. So I write a letter to the bank and I say, we have this thing going on and please do not release the funds to the bad nephew. And I get a letter back from the bank and they said, we are freezing the account. We are not going to release it to anyone because we're afraid if we give it to the wrong person, we are going to get sued. So we're not going to release it unless mom and the bad nephew, the aunt and the bad nephew tell us together in writing what they want, or a court order tells us what to do with the money. So now the aunt says to me, what do I do now? So I said, well, now you got to sue the bank and you got to sue your bad nephew. Can you imagine? It's her own money that she is now frozen out of this account, okay? So she said, Mike, I'm 84, I learned a good lesson, I'm not gonna do this again, but I don't want to do anything more. Well, somebody up there must have been watching because 4 months later, the bad nephew drops dead of a heart attack.
Yay!
Wow. Wow. Thank you, Aunt Carol. So anyway, because he died, she gets it back. But for that, she wouldn't have gotten her own money back, okay? So you have to be very careful with joint accounts, and I would much prefer, you have much more flexibility with a will than you do with a joint account. Also, I find really bad is, have you ever heard of an UGMA account? UGMA account? Yes. No. An UGMA account is it stands for Uniform Gift to Minors Act. You can open up an account for a child under the UGMA law, and the child can be under 18, which in New Jersey you cannot own anything in your own name unless there's a guardian taking care of it if you're under 18. So you don't want to get a guardian appointed for a kid, like a grandchild or something. So you can open up a Uniform Gift to Minors Act account in that kid's name. You use the kid's social security number, and you can gift money to that account. And the kid pays the income tax on the income up to $1,400. He pays it at his rate, which of course is nothing. And then anything over that gets taxed at his parents' rate, okay? So a lot of people like to do this. They like to do it for college. They also do 529 plans. And they make themselves the custodian of the funds on both of these accounts. And the problem with that is twofold. Number one, if you apply for Medicaid, this asset is not safe because you can get it out with under your own willpower. So they are going to tell you got to spend the money in those accounts, 529s and the UGMA accounts. Number two is you're the custodian. So now you drop dead, you walk outside, you get struck by lightning, run over by a bus. There is nobody now to be the successor custodian. So now I got to go to a court and get someone appointed to be your successor custodian. Don't want to do that. If you set up an UGMA account, You want to name, let's say for your grandson, you want to name your child, who is that child's parent, the custodian. Same thing with a 529 plan. That way they're at least out of your estate, and if 5 years go by, you don't have to worry about Medicaid. And when you die, we don't have to worry about switching this over through court proceedings. And let me tell you something. Once I have to, poke my head at all into a courtroom, you're talking usually a minimum of anywhere from $3,000 to $10,000. So you don't want to do that, okay? What you want to do is stay away as much as you can from courts, okay? And one of these is not to use these kinds of accounts. I just want to tell you one other horror story. I had a friend of mine, his name is George, we'll just leave it at George. He's been my friend since 4th grade. And George is one of 3 children. He has a brother and a sister. His mother died, and his father's the kind of guy, you know them all, he's going to go to the grave holding his last buck in his hand. And he's not going to give anybody control about anything. And he owns real estate on Route 17, or owned real estate on Route 17 in Upper Saddle River in Ramsey. And he spent most of the time down in Florida. So his daughter up here, who lives up here, was managing the properties for him. She said, Dad, let's open up a joint account so that I can put the rents in, I can use the money to pay the expenses of the properties and so forth. And over the years, $1 million built up in this account. Now, his real estate, his commercial real estate up here was worth about $2 million. Okay? Now, the fella died, and he died in the 80s. And in the 80s, if your estate was more than $675,000 and you had no spouse, you had to pay federal estate tax, and the minimum bracket over 675 started at 37% and went up, okay? So George came in and said, he said, Dad died, and could you help me handle the estate? I said, fine. He told me how much it was. I said, so your father's got an estate of about $3 million. At that time, this is not the way it is today, and if we have some time, I will tell you a little about it. I said, there's gonna be $800,000 worth of federal estate tax due. So he goes, oh, Dad said not to worry about it. Sis has the money. So I said, well, go to her and ask her to give you a certified check made payable to the Internal Revenue Service so that I can make an estimated payment on this $800,000 in tax due. So he goes, okay, fine. So he goes to her, and what does she say? She said, I talked to my lawyer, and joint is joint, and that is mine. And so that joint account is mine, and I am going to keep it. And she said, the will says that everyone gets everything equally. Well, that's only what's not joint, and not naming a beneficiary. So she says, that's $2 million left. And she said to George, who was the executor, you better sell the real estate, and out of the $2 million, pay the $800,000, and out of the $1.2 million that's left, I want my third. So she wanted to walk away with the $1.4 million, and the 2 brothers are going to get, $400,000. They were not happy campers, okay? So there is a law in New Jersey that says that it is presumed, there's a banking law, it says it's presumed that when you open up an account jointly, that you want the survivor to get the money. But there is also case law that says many people open up accounts jointly, not because they want the surviving joint owner to get the money, but because they do it for convenience, because it's easier for the person to pay your bills and stuff, and that you didn't want them to have it, you just did it for convenience. So my friend said to me, what can we do? I said, well, we can sue her and try to prove that it was a convenience account, not that he wanted her to have the money. And I said, is there anybody who can testify to that effect? I called the lawyer down in Florida who drew the will. And I said, why did he pick you? He said, he did a survey, I was the cheapest. Okay. And I said, I noticed that you said you wanted everything to go equally to 3 people. I said, do you know what this man owned and how he owned it? He said, I have no idea. This is really not my area. And I said, and you also put in the will that whatever assets the will controls is to pay all the taxes. I said, did you know that what was going to happen with the situation? He said, no, really, frankly, he said, I didn't know. I just did it. I put it in because it's in my form. Okay? What? Because it's in my form. Okay? He's got forms for wills. Okay? So he said, but the guy did want everything he owned. He told me he wanted everything he owned. He didn't specify what everything was, but he wanted everything he owned to go equally to 3 kids. So I told my clients, I said, This is going to be a very tough case to win because the only people who are going to testify to help you are you and your brother, and you and your brother are the ones who are going to get the money, so you really don't have a disinterested witness to help you. I said, but the only way we're going to do this is we have to make this the most expensive victory of her life, and we don't want to agree to anything, and we want to drag her into court at every opportunity we can. And I was very lucky. She hired a law firm from Roseland that had like 100 lawyers on the masthead. And so every time I was talking to her, I was looking at 3 blue suits, and I realized she's probably burning up about $50 a minute. And so I wouldn't agree on anything. I wouldn't agree on what the day of the week it was. We had to go to court and everything. Finally, she borrowed $80,000 on her house, which they inhaled in legal fees in about 5 months. And then she ran out of money. They didn't want to help her anymore. Just going to close his door. And so she finally cried uncle. Now, in the meantime, I had gone to court. When I started the suit, I asked the judge to order her to put the money in escrow because I was afraid she might, spend it or hide it or whatever. And by that time, she had already put it in 42 different banks. She even went to Utah and opened up an account in Utah to put the money in. And I was lucky. I got all the money back, so I know she couldn't use it as a war chest to fight us. And when she ran out of the $80,000 she borrowed on her house, she collapsed and she said, okay, I'll share it with everybody. And I said, well, we're not going to pay your fees. By that time, it cost my client $130 for me. The estate was in a 50% death tax bracket, so that $130 actually only cost them $65,000 because we could deduct it on her return, on Dad's estate tax return. And she had to pay a third of that anyway, so it only cost them $20,000 a piece. They got the $1 million back, so they were very happy about the outcome. But again, it's a problem with joint accounts, and it's a problem with naming beneficiaries, and I want you all to be aware of that, okay? Now, one thing I do want to tell you is what should you have? Everyone, I don't care how old you are, you're an adult in this country when you were 18, which is a kind of a scary thought, but everyone should have 3 pieces of paper, okay? The first one is a will. I must have 3 people a week that come in, they don't want a will, they want a revocable living trust. I say, why do you want a revocable living trust? They said, I heard Dr. Meltzer on the radio or Adrian Berg or one of these people, and they said you should have a revocable living trust because you can avoid what? Anybody? Probate. Probate, and what else? You can save what? Taxes. So they think they can save taxes and avoid probate. And of course they want to avoid probate so they can save what? Money. They don't have to pay who? No, these gouging attorneys, these bloodsuckers who are going to rip your hearts out in attorney's fees, and they're going to save it with a revocable living trust, okay? The first thing I want to tell you is a revocable living trust does not save you 1 penny in taxes. Income taxes, death taxes, any kind of taxes, doesn't save you any taxes, okay? So you don't do them to save taxes. Secondly, a revocable living trust will avoid probate. And most people don't even know what the heck probate is, okay? And I want to tell you what probate is, okay? In New Jersey, probate is we have to prove this person is dead, and this is their last will. If you can prove those 2 things, the will will be entered into probate. Now, I'm going to tell you how simple it is in New Jersey, and 90% of my clients do it on their own. I give them a sheet of paper telling them how to do this. All you need is the original will, the one with the inked signature. They will not take a photocopy. You must have the original, and so I want to digress here just for a minute. A lot of lawyers like to hold the original wills for you. Why? Because they think that you may misplace them, and a lot of people do misplace them, okay? And they also think that when you die, a member of your family is going to come back to collect it, and maybe they'll pick up some business. And I don't think there's anything wrong with either one of those reasons, except that I tell you, I've been practicing law 41 years, and I see lawyers lose them. Lawyers die, lawyers retire, law firms break up, nobody knows where your will went. I tell the clients, you hold the will, you make sure you put it in a safe place, maybe have one of your kids hold them, because many times the mom or dad has a stroke, nobody knows where the heck all the papers are, they have no idea where to find them, so I like maybe having a kid hold them, okay? But you hold them. Now when you go to probate the will, the surrogate, will keep the original will. So before you go down there, you make a photocopy of that will, okay? Do not take the staples out of the will. I had a case once where the guy was accused of swapping pages, and $35,000 later with a forensic paper expert, I proved he did not swap pages. Why don't you move closer? Why don't you move up closer if you're having trouble hearing me? It may help.
She won't bite, I promise.
You can sit right here. You'll hear me great. Okay? So you're going to need the original will, and you're going to need a certified copy of the death certificate. That's one with the raised seal on it. And you're going to go to the surrogate's office, which is in Hackensack in the courthouse. Actually, they just moved it out of the courthouse. It's in this nice administration building that they built down there. It's on the 5th floor. You do not need an appointment. They are open from 8:30 in the morning until 4:30 at night. Nobody knows it's 8:30, so if you get there at 8:30 in the morning, it is a ghost town. You walk right in. Although I will tell you, to get there at 8:30 in the morning, you have to battle what I call the Long Island Expressway of Route 17 and Route 4. And so I don't go down there then. And when I go down, I go down there like mid-morning. There's no traffic. You park. You walk right in. I've never waited more than 15 minutes. You give them the original will. You give them the death certificate. They will keep both of those things. You give them something less than $200. And that's probate. They then issue a piece of paper to you called letters testamentary. This is the official document that says you're the executor of the estate. Has anybody here ever probated a will without a lawyer in Bergen County? Yes. Was it hard?
No.
Was it easy? Cheap?
Very easy. Yeah.
Cheap? Easy? Cheap? Easy?
I did New York.
Oh, you did New York. Okay. New York is harder.
Yeah.
New York's harder. I'm admitted in New York. New York is harder. Okay, so anyway, that's probate. Now, once you're the executor, what's your job? You pay all the decedent's bills. You file their final income tax return. If their estate's large enough, you pay some death taxes. And then with what's left, you distribute it in accordance with the terms of the will. That's the executor's job. Okay, and you're entitled to a fee for that too, by the way, somewhere around 3%-ish, 3% or so, give or take, depending on the size of the estate. Okay? You don't have to take it. If you take it, you have to pay income taxes on it. But that's probate, okay? So to do a revocable living trust to avoid that process makes no sense, considering that the average lawyer is going to charge you about $3,500 to do this, and all it's going to save you is a trip to Hackensack at $200. It makes absolutely no sense in my mind. I think it's a total rip. There's even a company out there called the Loving Trust Company that will lovingly relieve you of $3,500. And I think it's a total waste of money. What you need is a well-drawn will, and then you can do wonderful things with a will. Things like you can have trusts inside your will. In this world, we have males and we have females. We also have two kinds of trusts. We have what are called living trusts. Living trusts are trusts that you create while you are alive. They start to function while you are alive. And there's two types of living trusts. There's irrevocable and there's revocable living trusts. I am not talking about living trusts. I'm talking about the other species. It's called a testamentary trust. This is a trust that's buried inside your will. It doesn't get created. It doesn't start to work until you're dead and your will has been admitted into probate. Okay? That's what I'm talking about. And you can have these kinds of trusts in your will, and you can have them like, for instance, I think anyone who's 18, first of all, if you're under 18, you cannot inherit unless you have someone appointed guardian for you, and they have to post a bond, which is going to cost money that they're not going to steal from you. And I think an 18-year-old with a large sum of money is a scary thought in my mind. Okay, so I have a trust I put in almost every will I do that says if anybody's under 25, they don't get it. Instead, it goes into a trust. Uncle Charlie, who is good with money, he'll invest it for the kid till he's 25, use it for the kid for health, education, living expenses. Whatever's left at 25, then the kid gets it outright. At least, I like 25. You could use 35, you could use 50. Some kids never grow up. You can use any age you want, but I'd say for the most part, people choose 25, okay? You're out of college a couple of years banging around the real world before you get your hands on the money, okay? So that's one kind of a trust that I put in almost every. I even do it for grandma, even though she's leaving everything to the kids. What if one kid is dead? His share is going to go to his kids. They may be underage. Put it in. Yes, sir.
Can you give us an example of a living trust and a testamentary trust?
Okay, a living trust, I have them now, and we're going to talk about them later because I did it with my mother. Okay, we create a living trust. It's a trust we create right now. I transfer mom's house to that trust right now. Now the trust is functioning, owns the house. Mom pays rent to the trust. The trust uses the rent to pay the property taxes, to pay the maintenance, to pay the insurance. That's a living trust that's functioning. Okay, and the difference between a revocable and an irrevocable living trust is an irrevocable one, you start, you can't change it. A revocable one you can always change. Okay.
Question.
Yes.
With the living trust putting someone's house in that trust?
Yes.
What are the benefits of it?
I'm going to get to that. We're just jumping ahead right now. But what I want to tell you, the big thing with the will, we're talking about testamentary trusts right now. You can have trusts in there that will save taxes. I've saved clients hundreds of thousands of dollars in taxes. using tax-saving trusts in your will. And the biggest thing is you're here because you may have disabled people that you want to give money to. The last person you want to leave money to is an old person or a sick person. Why do you not want to leave to an old person or a sick person? Well, number one, you're making them richer, and if they have to pay death taxes, they're going to pay more. And if they're old and they're sick, the odds are they're going to die sooner than other people. Also, if they're older and they're sick, they may wind up in nursing homes. We're going to talk about that. And nursing homes cost lots of money, and there is a program called Medicaid that will pay for nursing home. However, you have to be poor to qualify for Medicaid. How poor? You cannot have more than $2,000 worth of assets to be qualified for Medicaid. So what you've done now is you made this person richer, and now they got to spend their inheritance before they can get on Medicaid if they're in a nursing home. So what have you done? You've just given Chris Christie a nice gift rather than trying to save this money that you worked all your life to earn. Okay? So you can have what is called a supplemental benefits trust. It is inside your will, and this trust, I did it for my mother, and this trust is not considered mom's money. Therefore, it does not make her ineligible for Medicaid, does not knock her off Medicaid, yet it can be used to supplement what she gets from Medicaid, okay? To make her life better. Things Medicaid will not pay for, I can pay for it out of here. Okay? So that's what you want to do if you have a disabled spouse, you have a disabled child, you have a disabled family member you want to provide for. You do not leave it to them. You leave it to a supplemental benefits trust. So, and you can do these things in a will, and you can have lots of flexibility in a will. And one of the things I love is if you haven't screwed it up with payable on death accounts and joint accounts, you have 3 kids, your will simply says on my death, whatever I have left, no matter where it is, my 3 kids each get a third. That's it. Very simple. Okay, you want to keep it simple. Okay, so you can do all this with a will. So the first document is a will. And by the way, if you have any questions, please ask them as you have them. I'm only going to duck them if they're. I'm going to speak about them a little later. Okay, yes.
Is the house included in that? In the $200,000 for Medicaid?
It's 2,000, not 200. 2,000. You dropped a zero there. 2 zeros. Yes.
And the house is included in that?
Yes, it is.
Oh.
It
All
is.
assets.
All assets.
All assets.
I'm going to get to that in a minute. Okay, I'm talking about the patient. Okay, there are certain exceptions, but I'm going to get to that. The second piece of paper, though, this is the most important piece of paper you will ever have. It is not the will. It's the one I'm going to tell you right now, and that is a financial power of attorney. Financial power of attorney. A will only works if you're dead. You have a stroke, you get Alzheimer's, you get in a car accident, you have a head injury, something happens to you that does not kill you, but renders you incompetent, your will is not going to work because you are not dead. No one can handle any of your financial transactions for you unless they have your power of attorney. If they don't have your power of attorney, they have to go to court to become your guardian. This can be a real nightmare. I just finished one, took a year and a half. The legal fee alone was $32,000.
What if you're a joint bank, like I am part of my parents' joint bank?
Yeah, I'm going to get to that in a minute. I'll get to that, okay?
I was just gonna say this.
We also had to hire 2 doctors, court-appointed doctors, a court-appointed lawyer. By the time we got done, it was close to $50,000. All could have been avoided if the person had given someone their power of attorney. Now, people say to me, well, I'm married. I own everything joint with my spouse. What do I need a will for? I don't care if you're married. I don't care if you own everything joint with your spouse. If your spouse has a stroke and becomes incompetent, you cannot do anything that requires your spouse's signature, like sell your house, refinance it, list it for sale, rent it, file a joint income tax return, access your spouse's IRA, 401k, life insurance. I go on and on the things you cannot do unless you have given someone your power of attorney. And I got to tell you, I see young married couples, guy gets in a car accident, he's now a vegetable. They haven't done this, we have to go now to guardianship, and this is a real nightmare. You want to avoid that. A couple things I want to tell you. Number one, whoever give your power of attorney to, you are giving them the power to steal all your stuff. So you have to have 100% faith in who you give it to. Most people don't have a problem with their spouse. Maybe you have 3 sons, so you could say you want alternates. So you say, first I name my spouse can't do it, then Mo, then Larry, then Curly kind of thing, okay? You could have 2 kids. You could require 2 signatures. What you don't want to do is limit what they can do. Because we do not have a crystal ball. We do not know what the future holds. We do not know how much flexibility this person's going to need. So we want to give them the power to do everything you could do, including giving your stuff away. We want them that. Now, I'm going to tell you something that 95% of the lawyers in New York and New Jersey do not know, and I know they don't know because I teach them, okay? And that is this. There are certain things you cannot do with the power of attorney unless there is a specific bullet in that power of attorney saying you can do this thing, okay? New York, they call it superpowers. In New Jersey, we call it hot powers. You cannot exercise a super or hot power unless it is set forth, in a blurb, in a bullet in your power of attorney. Now, 80% of the clients come in my office do not have powers of attorney. Of the 20% who do, I redo 95% of them because there is this problem. So if your will says, your power of attorney says, I give my husband the power to do everything, that's all it says. Everything does not mean everything because there are certain powers that have to be set forth in your power of attorney or they can't do it, specifically set forth. And the most important power of all is the power to give away your stuff. And I can tell you that in both New York and New Jersey, unless your power of attorney specifically gives the person you're giving your power of attorney to the power to give away your stuff, they cannot give away your stuff. So for instance, in a husband and wife situation, we're trying to get the husband on Medicaid, the wife can keep the house. That is an exempt resource as long as the wife is living in it as her principal residence, okay? But you got to get it out of the husband's name. You got to get it out within 90 days of him getting on Medicaid. So we want to transfer from the husband to the wife. We're not paying for it, so we want him to gift his share of the house to the wife. He cannot do that pursuant to a power of attorney unless it allows gifts. Okay? Now I got to go to court for guardianship, and I got to ask the judge for permission to transfer the house. Just cost you anywhere from $5,000 to $15,000 for nothing when you could have, spent $400 and got a well-drawn power of attorney. Okay? So power of attorney, and I want to tell you, 95% of them, 80% don't have them, and 95% of them are either silent about gifts or have what I call a crippling gifting provision, like you could only give away $10,000 a year or something like that. You do not want that. You want to have a very well-drawn power of attorney. And I will tell you, of all the documents, that is the most important one. People say, you can have one that only becomes effective if you're incompetent. That's called a springing power of attorney. I don't like those. Because in order for someone to use them, to use any kind of power of attorney, I don't care what kind of power of attorney you have, the person has to be alive. The minute the person is dead, that power of attorney is null and void. So with a springing power of attorney, you've got to prove, number one, the person's alive. That's easy. But the second one is that he's incapable of handling his own affairs. That could be very difficult. I don't like that. I use what I call general durable power of attorney. With that one, the minute you sign the paper, the person can start using your power of attorney. All they have to do is prove you're alive. That's it. That's easier to do. Makes life easier for the person to do it. And people say, well, I don't know if I want to do that. They might steal from me. Well, if they're going to steal from you, if you have a springing power of attorney, the one only becomes effective if you're incompetent, they'll wait till you're incompetent and steal all your stuff. It's the issue.
Or make you incompetent.
That's right. So the issue is not what should what power should I hold back from this person. The issue is you've got to pick the right people, okay? And usually family members, kids. And I have to tell you, I've seen, people say, oh, these kids look what they did to his parent, did a terrible thing. I think 90% of the kids do the right thing, okay? 99% of the kids do the right thing, okay? And you cannot, I tell my clients, you cannot live your life based on what is the worst case scenario, what's the worst that could happen to you, because you would not get in a car, come to this course tonight, because people die in car accidents all the time. So anything you do, you're measuring, what is the risk I'm taking, what is the benefit I'm going to have? Yes, ma'am. Okay, there's two kinds of power of attorney. One is called springing. Only becomes effective if A, you're alive, and B, you can't handle your own affairs. That's a springing power of attorney. And the other one is called a general durable power of attorney. That one becomes effective the minute you sign it.
Right, but give the negative about the springing power of attorney.
The person has to prove you're alive, number one, and number two, you are incapable of handling your own affairs. Incapable of handling your own affairs can be quite difficult. Some places will require a court order. You want to stay out of court. You want to keep things simple. And if you have any misgivings, you don't have to give the person a piece of paper. I can do a general durable power of attorney. Tell my daughter, you got my general durable power of attorney. When you need it, here is where it is in my house, in my under my underpants, and the second drawer in my thing. She can't use it unless she's got it. But I think that you should have a power of attorney. If you have to have a springing, I'll settle for it, but much better if you have a general durable power of attorney. Yes, ma'am.
You mean it springs back to you?
No, springing back doesn't spring back. All springing means is it doesn't happen until you're incompetent. Then it springs into effect.
Okay, and the question I really had is, I'm just thought that I heard this, and I want to make sure, that if you give the power, the gift of your house to somebody,
Yes.
and you need to go to a nursing home,
Yes.
that house will not be held against you, and you might be able to qualify.
Okay, this woman is absolutely incorrect, and we're going to get to it in a little bit. Okay? Yes, sir.
As with the, do you need the original for the power of attorney?
You only need the original for certain things, photocopies for others, and I always tell my clients you never give anybody originals of anything because you may never get them back. And if you can't find the originals, it can be presumed that you destroyed them, that you didn't want them anymore. So you only give away photocopies. I can tell you, if you're using a power of attorney to sell a house, anything to deal with real estate, you would have to file that power of attorney at the Registry of Deeds when you file the deed, but you do get it back after it's been filed. They microfiche it and then they give it back to you. Okay? So that's power of attorney. That's the number one most expensive, most important document of all. The third one is a living will. Who's going to make your medical decisions if you are incapable of doing it yourself? You know, it says if you're terminally ill or permanently unconscious or in a permanent degenerative state, that if you're on life support, you don't want to be on it, or if you're on, you want to be removed from it, and if you're not on it, you don't want to be put on it. Now, that's if that's what you want. This is New Jersey has a suggested form. This is what the form says. I had a client come in about a month ago. He said, Mike, he said, I don't give a damn what my quality of life is. Okay, how much pain I'm in, okay, how much it costs. I want every machine, every medication, every procedure known on the planet used to keep me alive as long as possible. Now, that may not be what you want, but that's what the guy wanted, and that's the kind of thing I drew for him. I have had people say, you know, the form says when you want to be removed from life support, you have to be removed from feeding and hydration. Some people get skittish about being removed from feeding and hydration. I try to remind them about, I don't know if you remember the Shivo case. That woman was brain dead, but she was kept alive because she was fed and hydrated. And I don't know if you remember the Karen Ann Quinlan case, but when they took her off the respirator, they said she was going to die immediately. Well, Karen lived 9 more years after that, and I'm told she was in a reverse fetal position. She died, she had covered with bed sores. She died of overwhelming infection. How much of those 9 years she enjoyed, I don't know. But I've had clients say, okay, you know what? Don't give me the food, but you hydrate me. I've had people say, take the feeding and hydration away, but I'm afraid I'm going to smother. I want oxygen. You can, all I'm trying to tell you is you can modify this any way you want to satisfy what you want.
Can you tell them, have somebody put a pillow over my head and kill me?
This is not Dr. Kevorkian time yet, no. You have to go to Oregon. They do have assisted
But you
suicide
can't
there.
put a Kevorkian type clause in your living will.
No. I mean, you can, but nobody's going to, and nobody's going to follow it unless they want to commit a felony.
She'll do it. I'll do it.
Yeah, okay. All right. So anyway, those are the 3 pieces of paper, okay? Now I want to tell you, I also teach a course on estate planning, and I don't know when it's going to be here, but I teach you,
April
okay.
18th.
I will tell you that I do start off with these 3 documents, so you should just know there's a little bit of overlap. I want to tell you this, that there are 2 taxes that you have to worry about when you die, and I don't want to spend a lot of time on it because my other course is going to be that tax. One is the state of New Jersey, and the other one's the federal government. Let's talk about the state of New Jersey. New Jersey, as you are probably aware, you're now paying 23 cents a gallon more for gasoline. And that is because New Jersey raised the gas tax. At the same time, they voted to phase out New Jersey's estate tax, okay? Estate tax. You do not pay tax at all to anyone, federal or state, if you leave it to a spouse. You can leave unlimited wealth to a spouse, $100 million, you will not pay any estate tax. If you leave it to children, grandchildren, great-grandchildren, etc., stepchildren, you will be subject to estate tax, New Jersey estate tax and federal estate tax. Last year, the total was, federal estate tax was New Jersey estate tax was $675,000. If you left a total, not per person, a total of $675,000 or more to children, grandchildren, great-grandchildren, great-great-grandchildren, stepchildren, if it was over $675,000, you would pay New Jersey estate tax. The first bracket, 37%. New Jersey is the most expensive state in the country to die, okay? When they passed the gas tax, to get the gas tax through, they said people dying on or after January 1 of 2017 right now, they raised the limit from 675 to 2 million. So congratulations, you have all made it. If you have under $2 million, including life insurance, retirement benefits, houses, everything else, and you die, you leave it to your kids, no tax. If you are married and we do the right kind of will, you can each leave $2 million, no tax, so you can have $4 million. But if we keep at least one of you alive, if you're married, you keep at least one of you alive until January 1, 2018, which is less than 10 months away. New Jersey has no estate tax anymore, gone, okay? So there's no tax at all. I will tell you that the estate tax is the 4th largest revenue generator in the state. The Democrats have vowed to bring it back. Whether it'll come back or not, I don't know. All I know is it took 40 years to get rid of it, and now it could come back, okay? But for now, we got the 2 million. There's talks that the Democrats may try to freeze it at 2 million. I don't know. I don't know what's going to happen, but they have to have enough votes to override a Christie veto unless they wait until a Democrat gets in, okay? I don't know if a Democrat's going to get in, but it's probably a good chance of it. You know, New Jersey is a Democratic state anyway. So that's New Jersey tax. But let's not forget, New Jersey has 2 taxes. It has a state tax, which we just talked about, which is going to be gone in a little less than 10 months. But it also has an inheritance tax. Nasty, nasty, nasty tax. You only pay inheritance tax if you leave your wealth to a brother, a sister, a niece, a nephew, a friend. Brother, sister, niece, nephew, friend. Friends include son-in-laws, daughter-in-laws. Anybody in the world who is not a descendant or your spouse, okay? And that tax can be as much as 15% from $1, and it goes up to 16% is the maximum. And I will tell you that that tax is not going away. Only New Jersey inheritance tax, only New Jersey estate tax is going away. So I had a woman in Ridgewood. She had $1 million. She came in with her niece. She said, my husband died, I have no children. My niece takes care of me. I love her. I want to leave her my entire estate, $1 million. I said, you can leave her $1 million. I said, but because she is your niece, you're going to be subject to New Jersey inheritance tax, and at $1 million is going to be $160,000. So when you die, she's going to have to pay $160,000 of your $1 million to New Jersey in inheritance tax. She goes, she goes, and I'm also thinking, by the way, of selling my house in Ridgewood and moving into independent adult living someplace. So I said, well, the way you could get around this tax is you can give everything to your daughter, and if you live long enough, you will avoid that tax. She goes, I don't want to give up control. I don't want to do that. What else can I do? I said, well, you're thinking about selling your house and moving into independent living. I said, I'm admitted to practice in both New York and New Jersey. In New York right now, you can have $4.5 million, no tax, no matter who you leave it to. So I said, you sell your house, you move up to Suffolk, it's only 18 minutes up Route 17, and you will save your niece $160,000 worth of tax. And that's what she did. She sold her house. She moved into a senior living up in Goshen. She likes it. And she saved her niece $160,000. This tax is not going away. Do not get confused. It's not going away. We'll talk more about that in the other course. Yes, sir.
This inheritance tax, does that apply to heirs that live elsewhere than in New Jersey?
It doesn't matter where the heir lives. It's where the person died a resident. So you died a resident of New Jersey. It is subject to the tax no matter where the people are who are going to inherit your wealth. Okay? Yes. Yes, sir.
So in the language, by the inheritance tax is paid by the person who inherits?
That's correct. It comes out of their share unless the will says otherwise. Okay?
What about
Federal. Okay, now federal, the way federal works, if you are single, you can leave $5.5 million to anybody and pay no federal tax. And if you're married, you can leave $11 million. So for 99% of the people, they don't have to worry about federal death tax anymore. And if you're married and you have more than $11 million, please let me know. I'd like to take you out to lunch. Okay? Okay, so that's taxes. Now, let's talk about Medicaid. Let's talk about nursing homes. I read an interesting statistic, or I saw an interesting statistic on the internet, at a website run by actuaries. They are the guys who set the odds for the insurance companies, so the insurance companies know how much to charge for premiums on insurance. The chance of you having a house fire during your lifetime and having $10,000 worth of damage is about 1 in 1,200. The chance of you being involved in an automobile accident during your lifetime and having $10,000 or more in medical bills is about 1 in 250. The chances if you are 65 or older of winding up in a nursing home for 2.5 years or more is 1 in 11. And if you are 80, it's 1 in 3. Okay? And if you realize that the baby boomers, of which I am one, is approaching the age where they're all retiring. And by the way, 19,000 people apply for Medicare every day. So that means 19,000 people are turning 65 every day in this country, okay? And that's not with the baby boomers, just the front edge of the baby boomers are now going through this. So that's only going to get worse and worse. So when you see Hyatt and various hotel chains building assisted living, building senior living, you know they know the bulge is coming, okay? And this stuff is expensive. And how do people pay for it? Well, if you're lucky, you have long-term care insurance, okay? If you're already in your 60s, it's going to be very expensive. But if you bought it a long time ago, way back when the insurance companies set premiums that were ridiculously low, they forgot that they might have to pay out on these policies, and now they're all bleeding from every pore, and they're all not selling it. There's only one company that's selling traditional long-term care insurance, and I just can't think of the name right now. But there's only one company out there, and I had a client who she was 72. She's in excellent health. She applied for it, and they said they would give her $100 a day, which the average nursing home now is about $500 a day. Okay, $475 a day. They would give her $100 a day for 3 years, but they have a 100-day deductible, so they'll pay for the first 100 days of those 3 years. So you really only got 2 2/3 years of coverage, and they want to charge her $8,100 a year in premium. So it's very, very expensive. Okay. The other thing is, up until about 10, 15 years ago, they would tell you that they have never raised the premiums. Now, they don't say that anymore. I know clients whose premiums have doubled, gone up 40%. They can't drop you, but they can raise the premiums. They can't raise yours individually, but they can raise all the people whose contracts were yours. And so, but they're always changing contracts, so they can raise people's contracts, and you can get more. It could cost you more money. I can tell you that I am 69. When I was I'm not 69 yet. 3 more weeks I'll be 69. I'm 68, and when my wife was 58 and I was 62, we applied for long-term care insurance. They would not write it for me because I have a history of migraines. They said they considered migraines seizures, and so they told me that come back when you haven't had a migraine for 5 years, because my wife was a nurse at Columbia Presbyterian. I hadn't had migraines in years, so she thought I had a brain tumor. She moved me to Columbia for the $1 million workup, MRIs, CAT scans, all that stuff. So now it's all over my medical records, and so I can't get the insurance, but they agreed to write it for my wife. She's in very good health. She got $6,000 a month and a pot of $300,000, so she could get $6,000 a month until she exhausted the $300,000. She could get it for home care, for assisted living, and for nursing home. A lot of places will not cover all three, maybe only cover one of those three, or two of those three. I don't know about you, but I have never seen a nursing home with barbed wire around it trying to keep patients out. Nobody wants to go to nursing homes. Certainly, if I ever was sick, I would rather have a live-in taking care of me, preferably a 26-year-old. The French maid outfit would make me very happy. I don't know if my wife would do that for me. But you want to get insurance that will pay for home, assisted living, and nursing home. And there are things called activities of daily living, ADLs, okay? And these are things like, can you toilet yourself? Can you bathe yourself? Can you feed yourself? Can you take your medications? Can you eat? Different stuff. There's 6 of them. The better insurance, long-term care insurance, will pay if you're unable to do 2 of them. The crappier ones, you have to be unable to do 3 of them before they'll pay, okay? So long-term care, my wife's policy every year goes up 5% to $6,000 and a pot of $300, and her premium costs me $3,000 a year, which I don't think is too bad. I figured that in 20 years it'll cost me $60,000. In 20 years, probably that's going to get me a month and a half in a nursing home. That's $60,000. So I thought it would be a good deal. And that $6,000 would probably be up to about $18,000 by then. Probably still not enough to pay the nursing home, but not too bad. There are other hybrids where you can buy life insurance. You pay for the policy. If it doesn't pay for your nursing home, you can get it when you die. There are all kinds of crazy things out there, but you might want to look into those. Typically, I found that they're very expensive now, and only clients who've had them 15, 20, 25 years, does it pay for them to keep on doing them, and I tell them, shame on you if you cancel the policy or reduce the benefits after you've paid all these years, okay? So that's number one. The second program that will pay for nursing home is Medicare. Now, not Medicaid, Medicare. Why do we like Medicare? Because it is not needs-based. What does that mean? You do not have to be poor. Okay, you can have lots of money and you qualify for Medicare. What you have to be is 65 or older or disabled. If you're disabled before 65, you have had to have paid into the Social Security system for 40 quarters, which means you had to be employed for 10 years. Or you have to be, you have to do that, but you have to be either a U.S. citizen or a resident alien for 5 years, plus have paid into the Social Security system. You have to have been sick enough to be admitted into a hospital for 3 midnights, not there for observation. You have to be there. You have to actually have been admitted for 3 nights. Don't let them try to leave you there just for observation. You want to get mom there admitted for 3 nights. And then within 30 days of that 3 nights, they have to refer you out to a SNF. A SNF is a skilled nursing facility where you need either rehabilitation or you need skilled nursing care. Skilled nursing care, you need injections, you've got sores, you've got wounds that need to be attended to, you're on a machine, you've got tubes in you. You need skilled care or you need rehab. Now, if you need skilled care or rehab, Medicare will pay for 100% of the first 20 days. And they will pay for 80% of the next 80 days. But 100 days is all they're going to pay, okay? And once you reach the 21st day and you start paying 80%, if you have supplemental insurance, AARP or Blue Cross Blue Shield, something like that, if Medicare is paying the 80%, your supplemental insurance will pay the other 20%. Once you use up your 100 days, you are done, okay? The other thing I want to tell you is, once you don't need rehab, you're done. Let's say the 20 days, now you're not getting any better. They're going to want, you've plateaued, they call it, they say you're no longer skillable. They want to take you off Medicare. Well, I want to tell you something. Not progressing is not the standard. There's been a recent case, 3-4 years ago, and it says it's not that you're not getting better. It's if they took you off of rehab, would you deteriorate? If the answer is you would deteriorate, you have a right to remain on it, and you should appeal that decision, okay? Secondly, so you have a stroke, you're in there for 20 days, you're no longer skillable, they want to get rid of you, you could try appealing. I don't know why these nursing homes don't extend it, because they make a ton of money on Medicare patients, but for some reason, they're very stingy after 20 days, okay? But if you don't need it, you're not going to get the 100 days. Skilled care. If you don't need skilled care, I had a guy who was a diabetic, he had to get 4 or 5 injections every day, and they switched him over to a pill. You do not have to be in a skilled facility to get a pill. No more Medicare, okay? I'm there for 100 days. I broke my right leg. I'm there for 100 days. Now I'm out. I go home. I have to stay home for 60 days to recharge that 100 days, or I have to have a different illness. So I broke my right leg, I'm in for 100 days, I go home, I break my left leg, I can go immediately back in for another 100 days. It's a different illness. But if it's the same illness, you have to be home for 60 days before you can do it again. That means you have to be admitted in a hospital again for 3 midnights and all that stuff, okay? But that's Medicare. Now Medicare will pay a good chunk, and Medicare is wonderful bait for nursing homes, because nursing homes want you because they're making like $1,500+ a day on you. So they want you badly. And you want to use that for bait later on for something I'm going to talk to you about later, okay? But you have Medicare. Once Medicare has run out, you have to privately pay until you are poor enough to be on Medicaid, not Medicare, Medicaid, okay? Now, how poor do you have to be? I can tell you this, New York is much kinder to Medicaid patients than New Jersey, much kinder. And I'll tell you the differences as we go along. New Jersey, the patient can have assets of no more than $2,000, the patient, okay? In New York, it's around 14 grand.
Around New York, it's what?
It's around 14,000 if you're in a facility in New York, okay? The spouse of the patient, let's call that the healthy spouse. The healthy spouse can keep the marital home as long as it is their primary residence. And there is no limit. You can have a $10 million marital home as long as it's your primary residence. The healthy spouse can keep it as long as they're living in it as their primary residence. Now, I had a woman, her husband was up here in Bergen County in a nursing home, and she owned a house in Manna at the time, pre-Sandy. I don't know what it's worth now, but it was worth about $1.5 million then. And she said, I'm running out of money. I got to get my husband on Medicaid. I said, and she had an apartment in Hawthorne that she was paying on a month-to-month basis, and that was her primary residence. She was using that for everything. So I said to her, your house in Manna is in jeopardy. I said, you have to go back and make that house your primary residence, and then I can save it. She said, how am I going to do that? I said, well, you must sleep 4 nights a week there. I would change the address on your driver's license, on your car registration. I would register to vote there. I would actually vote there. And you got to spend 4 nights a week there. She goes, do I actually have to sleep there? I said, well, Medicaid has been known to send investigators out to talk to your neighbors, and I don't think they're going to lie for you. And I told her, Allenwood is a lovely federal penitentiary in Pennsylvania. They have tennis courts and everything. You make a whole new circle of friends, but it is not in my future. Okay, and I said, if you're not going to do that, I'm not going to represent you. If you can do that, I'm not going to represent you. So that's what she did. She went back, and she was lucky she had a month-to-month lease, so she was able to give up her apartment. She went back. I got her husband on Medicaid. Once he's on Medicaid, doesn't matter what happens to mom. She could hit the lottery. She could inherit millions. She could give assets away. It only affects her Medicaid eligibility, okay? So the first thing I want you to know is that the healthy spouse can keep the marital residence as long as they're residing in it as their principal residence. Now, everything else, I don't care if it's in the husband's name, I don't care if it's in the wife's name, they look at husband and wife like you're a unit, like you're one person. And because they look at you as a unit, they don't care who owns the stuff. Everything is considered in New Jersey an available resource. They don't care what fire you have to walk through to get it. If it's an IRA, you got to break it. You got to pay income tax. They don't care. If it's an annuity, you got to break it. You got to pay penalties and income tax. They don't care. If it's life insurance, you got to cash it in. They don't care. It's all available. If you can get at it, which is if you have a revocable living trust, you can revoke it. They want you to revoke it. It doesn't protect it, okay? And you have to spend it down. Now, the healthy spouse can keep remember, she can keep the house and 1/2 of the available resources, but that 1/2 cannot be more than $119,000, okay? So I had a client, his wife was in a nursing home on a respirator, costing him $30,000 a month, okay? He said, Mike, I got a house worth $400,000 and I got $600,000 in the bank, but at $30,000 a month, in 20 months, I'm going to be broke. What can you do for me? I said, well, I have an easy thing that you can do, but it's expensive, and then I can get your wife on Medicaid. And I have a hard thing that you can do, and I can save all your money. He goes, what's the easy thing? I said, the easy thing is you keep on spending $30,000 a month till you're down to just your house at $119,000, and then I'll get her on Medicaid. He goes, Mike, that means I have to spend $481,000 till he's down to 119 to get on Medicaid. I said it was easy. I didn't say it was cheap. I told you it was expensive. He goes, what's the hard thing? I said, you could keep your house and $119,000. You have a $400,000 house. I said, I want you to sell that $400,000 house. You'll have $1 million. Go out and buy a $900,000 house, and I will get your wife on Medicaid the first of the following month. He goes, Mike, how the hell am I going to pay property taxes on a $900,000 house? And at 77 years old, just the thought of moving is going to give me a heart attack and kill me. So I told him what I tell most of my elderly clients. I said, I want you to come back with one of your kids, the one who is the brightest bulb on the tree. Okay? So he came back with his son, and I explained this to his son, and I said, I want Dad to sell the house, and then I want him to use the money to, buy a new house, etc. And I said, and I don't want to take the time For him to sell a house could take months. In the meantime, you're bleeding $30,000 a month. I said, we can get appraisals. And I said, son, if you have the cash, you could buy Dad's house for its current market value, not a break, and then you go sell it and get your money back. And that's what we wound up doing. So he had the $400,000 right away. We went out, we bought a $925,000 house. The first of the month following that, I got his wife on Medicaid. Now I told him after that, doesn't matter what happens to you, Dad. You can inherit millions, you can hit the lottery, you can give assets away. It only affects your Medicaid eligibility, not your wife's. And I said, this gun has 2 bullets in it. One was aimed at your wife, we just dodged that bullet. The other one is aimed at you. Now, you get older, you get sick, you go in a nursing home, you do not have a spouse living in your house anymore. It is no longer an exempt resource. They are going to make you sell that house and spend everything down to $2,000. So he said, what do you want me to do? I said, I want you to give everything to your sons or to trust that I'm going to, I don't like making gifts outright to children, I'll tell you why in a minute, but to your sons, to trust, okay? He said, well, let me think about it. That was 4 years ago. He never did anything. His son now comes in and says, Dad's starting to get dementia. What should I do? I said, we should have put the trust 4 years ago because there was a 5-year look back, which we're going to talk about. You would have been 4 years into that 5 years. Now, if he goes into a nursing home tomorrow, you're going to have to pay for his care for the next 5 years. It's going to cost you like $600,000-$700,000. He said, I know. He says, we should have come early. He said, but my father's mad at you. I said, mad at me? Me? He said, yeah. I said, why is he mad at me? He said, well, the house went down about $90,000 since he bought it in value. I said, $90,000. I said, I save him $30,000 a month. I said, he should be kissing me on the lips. And he said, well, not really, but he said, yeah, I understand, and we all understand it, but that's how Dad feels. So I don't know what we're going to do with him. He's still pondering what to do, okay? But I can tell you that, that's the problem. Now, how do people spend out? First of all, the other thing in New York is that they don't consider retirement benefits an asset. Did you hear what I just said?
Wow.
So if you have $1 million IRA, you do not have to go through it in New York. And I've sent people up to New York just because of that.
We should all
Okay.
move to Suffolk.
Yeah.
There we go.
Well, you don't have to move there. It's where your parent goes into the nursing home. That's the jurisdiction that will control. So you want to say, but you want to know something? I tell people go up to Suffolk. Oh, it's too far to travel.
I live in
They'd
Manna.
rather spend $250,000. I mean, that you could get a limo every day and spend half that money. So anyway, now how does people spend down to $2,000, or how do they spend down to the house in 19? You spend it on legitimate living expenses. You spend it on your care, and you give it away. Most people give it away to children. Okay. Well, everybody was giving away their assets yesterday and getting on Medicaid today, and Medicaid got angry about that. And for the last 35 years, they have been increasing the penalties for people who give away their assets. The last time they did it was on February 8th of 2006, and you can thank President Bush for this. And basically what that law said is, if you give away any assets, we are going to not pay for your Medicaid, not pay for your care. You will be ineligible for Medicaid for a period of time for the next 5 years. Okay, for a period of time. What's that period of time? Currently, if you give away $9,500, which comes down to $330 a day, you give away $9,500, they will not pay for 1 month of your care for the next 5 years. Okay, so I give my kid $30,000 today. I'm fine. I got lots of money. 4 years from now, I'm broke. I have a stroke. I go into Valley Hospital. I want to get in a nursing home. They're going to say, okay, is Manna sick enough? You have to pass the PASS. It's called PAS. It's pre-admission screening, meaning you have to be sick enough to be on Medicaid. Believe it or not, I had a woman who was conducting a business out of her room in the nursing home. They threw her off Medicaid so she wasn't sick enough. Okay, so number one, you have to be sick enough. Number two, you have to be poor enough. I got less than $2,000. And number three, they're going to go back and look through all your financial records for the last 5 years, and they're going to see that I took $30,000 out 4 years ago. They say, oh, man, we saw you took $30,000 out 4 years ago. 30,000 divided by 9,500 is about 3. We are not going to pay for the next 3 months of your nursing home. We don't care who pays for it. We don't care if they put you out in the street. We're not paying for the next 3 months. Now, since nursing homes cost about $15,000 a month, for me to save $9,500, it just cost me $15,000. Makes no sense. Okay, so you've got to have some kind of a strategy. And I will tell you, in New York, there are various loopholes which I am not going to discuss now. I do not have the time. But you have to have some kind of a strategy. Now, I will just tell you there are certain exceptions. When you give away assets, there are certain exceptions to the rule where you don't have this 5-year penalty. Do not get confused with the IRS. The IRS says you can give away $14,000 a year per person per year. I can give you each right now, write out a check for $14,000 a piece to each one of you. Don't worry, it's not going to happen. But I could do it. The IRS doesn't care. Okay? Medicaid cares. You give away $330, they will not pay for 1 day of your care for the next 5 years. I had a client who 2.5 years ago, he wasn't even sick. His grandson got married. He gave him a $1,000 wedding gift. They did not pay for 3 days of his care because he did that. Okay? So these people are very heartless when it comes to this stuff, okay? And they are trying their best not to put anybody on Medicaid. There is one exception. It's called the child caretaker exception. There are other exceptions, but one of them is called the child caretaker exception. It says if a child, not a niece, not a nephew, not a friend, but a child's principal residence is in the patient's home, the child, and the child has been giving the patient a level of care for 2 years before they went into a nursing home, that without that level of care, the patient would have been on Medicaid 2 years earlier. They will allow the patient to give the house to the child, no 5-year penalty. Okay? There's also something called the sibling exception. You have siblings that own a house and live together for at least a year. They'll let one sibling give their share to the other sibling, no penalty. Okay? What else can you do? I'm going to tell you what I did with my mother, and then we're just about out of time. 3.5 years ago, my mother died. She was 98. My mother walked three miles a day until she was 95, which is probably why she lived to be 98. She had good genes. Her cholesterol was never more than 125. Mine, last time I had it taken, was 89, so I got that from her, and I eat all kinds of crap. And my mother had low blood pressure. Her blood pressure was about 110/64. But I got my father's high blood pressure. But in any event, my mother had $500,000 back in 1993 when she was 79. I said to my mother, Mom, I want you to give all your money to Joanne and I. She goes, I have one sister. Her name's Joanne. She's a wonderful person, and I trust her holding my wallet. We both have a great relationship. My mother. So my mother said, why do you want me to give all my money to you and Joanne? I said, I'm afraid you're going to get sick, and it's going to go up in smoke in healthcare costs. So my mother said, fine, I have no problem giving you and Joanne my money, but I have one rule. I said, what's that rule? She said, I never, ever, ever, ever want to have to ask your wife or my son-in-law for my money. Okay? So I was afraid if she gave $250,000 to me and $250,000 to my sister, and my sister died before my mother, and I will tell you, my sister's 5 years older than me. She has had lung cancer, so it is not out of the question that she could die before my mother. Now I got to deal with my brother-in-law. Now, don't get me wrong. He's a very, very nice man. I'm sure he would give me no trouble. But it's not his mother, not his money, not his business. He is not a member of the tribe, okay? I was also afraid when my sister got divorced, she went bankrupt, she got sued, she spent it on something stupid, or I did those things, could jeopardize my mother's money. So instead, I created an irrevocable living trust. Irrevocable living trust. Once my mother set it up, she could not undo it. The trust gets its own tax identification number, just like a person, you have a social security number. The trust has a tax ID number. I moved my mother's $500,000 into this trust. So you can use these trusts for houses, you can use them for stocks, you can use them for bonds, you can use them for annuities, you can use them for lots of things, okay? Cash. I moved my mother's $500,000 into this trust. Now, what's the beauty of it being in the trust? The beauty is that neither my sister nor I own it. The trust owns it. So it's like in Fort Knox. So it doesn't matter what happens to my sister and I because we don't own it. We could die, get sued, go bankrupt, get divorced. It is not our money. It does not affect it. In fact, my sister, her kids were applying to college for college loans. She did not have to put it down because it wasn't her money. It's the trust money. My sister and I are just the trustees. We run this trust, okay? Now, I will tell you that the trust says my mother is entitled to nothing. Because if she was entitled to anything, Medicaid would say, go exhaust what you can get before we're going to pay. So the trust said my mother's entitled to nothing, and it said that my sister and I had this money, and we could only give it to ourselves. And when my mother died, the trust would end, and we'd split the money that was left. So my mother had to take a leap of faith that my sister and I were not going to screw her because we could legally screw her, and there was nothing she could do about it. So she had to be willing to give up control as well as take the leap of faith that my sister and I were going to screw her. Well, of course, she knows her kids, And I will tell you, my father's old school Italian. He used to pound on the table. Everybody would run to the corners and quiver in the corners. And my mother barely knew how to run her checkbook. So when she heard that we were going to take it over, she was actually delighted that we were taking it over. And my mother needed about $1,500 a month to live, about $20,000 a year. And I didn't want to give her a check for $1,500 a month. It was too much of a pain in the neck. So when she'd need money, I'd write her a check for $20,000. Would last her a year, give or take a month or two, one way or the other. Everything went copacetic till she turned 90. She got macular degeneration, blind in one eye and the other eye going. And at 90, blind in one eye and the other eye going, she's still driving on the parkway back and forth from Tom's River. And in 1 month, she gets into 2 car accidents, okay? So my sister says, go down and get a driver's license. She won't go. She wants me to go down and get my mother's driver's license. So I go down, and I said to her, I said, Ma, I said, you cannot drive anymore. You're going to kill yourself. You're going to kill somebody else. You got to give me the keys. And to my surprise, she didn't give me a big fight. She said, okay, I'll give you the keys, but she said, I want you to know that there was no public transportation here. There was no way for me to get to the stores, get to the doctors. I cannot live here anymore. And I will tell you, my mother used to be an impeccable housekeeper. The place was filthy. The refrigerator had rotten food in it. She was getting a little bit of short-term memory issues going on. So it was a time to pull her out of there anyway, okay? So I found a very nice assisted living that was about a mile away from my sister. Now, my sister's 5 years older than me. She's retired. She adores my mother. And remember, my mother was still walking 3 miles a day. So on a nice day, my mother could walk over to my sister's house, kill the day, and walk back. Why am I telling you this? The place cost $5,700 a month, which is about half what a nursing home costs. But I don't care what you say, $5,700 a month is still a hell of a lot of money, okay? But because I had done what I did 11 years before, I did it when she was 79, now she's 90, you have to do it 5 years before. I was able to get my mother on Medicaid, and instead of paying $5,700 a month, we only paid $700 a month. That we saved $5,000 a month, that's $60,000 a year. This went on for like 7 years. That's $420,000, would have wiped her out. And then we only used the money for my mother. We furnished her apartment, got a big screen TV, we got her $8,500 hearing aids, we bought all her clothes, we sent her on vacations. 11 weeks before she died, she fell out of bed. She didn't break any bones, but she was very frail. We hired a live-in to stay with her, to toilet her, to feed her, to clothe her, to bathe her, to be her companion. Cost us $1,000 a week. We had plenty of money to pay for those 11 weeks. We had plenty of money to pay for years. When my mother died, we still had about $450,000 left in the trust. No probate, no nothing, even though probate is nothing. All I had to do was write a check to my sister for half, a check to me for half, collapse the trust. That was it. This is something you should be thinking about doing for anyone who is sick. I don't care if you don't make the 5 years. Suppose you put it, it's not like if you don't make the 5 years, you fall off a cliff and you save nothing, okay? Let's say you did it and after 3 years you get sick. Well, we only have to pay for 2 more years. If after 4 years you get sick, we only have to pay for 1 year. So it is a shrinking exposure, okay? Every day you're in, you're saving potentially $450 a day because that's what the average nursing home is costing. So you want to do this because the more you're into it, the more money you're going to save, even if you don't make it all the way. With that said, I have to tell you, I'm over. I'm done. I just want to tell you a couple things, and that is that it's our office policy that the first visit is for free. So if you ever want to come in and see me, you will have a piece of paper that has my name and phone number on it. Please feel free to give me a call. You can speak to anybody in the office, and they will make you an appointment to see me, not anyone else. If you have a will, you have a power of attorney, you have a living will for the person you're coming to see me about, bring those. I want to look at them. Bring me a list of all their assets and debts and anything that they may have given away in the last 5 years. I do not need precise numbers. I just want to get something rough so that I can decide, just get a panoramic view of what's going on to tell you what I think you might do, which I'd be happy to do for nothing. And we do 95% of this work we do on a flat fee basis, which means we quote you a flat fee, give it to you in writing. You want to do it, fine. You don't want to do it, it's fine. But you know how much it's going to cost before you get in. You don't get surprised later on. Some people charge by the hour. We don't do that for this kind of stuff. With that said, I want to tell you that I'm glad you all came. I only saw a couple of you go to sleep, which is good. And if I see you again, great. Anybody have any questions? Yes, sir.
Back to the stable part. If you want to make a copy of the will in
Yes.
New Jersey, if you pull the stable.
It's not the end of the world, but if you want to be safe, try to not to put them out.
If it's all, every page is a numbered and initialed.
If you want to be careful, don't do it. If you 99% of the time, it will not be a problem, but that's the kind of lottery I would win. And so I'm just telling you, it's not fatal if you've done it, but don't do it if you haven't.
What about New York?
New York is the same,
Same.
okay? In fact, if they see you took the staples out, they want an affidavit that you didn't, under the penalties of perjury, that you didn't swap the pages. So you want to keep out of it. I even had one where my secretary, without consulting me, sent in one that was never stapled. Wow, that was unbelievable. Okay? Anybody else have a, yes, ma'am?
Yeah, on that Medicaid, if you have a pension coming in, you get
You're going to
over
lose your pension.
$1,000.
Your pension is going to go, if you're in a nursing home and you're single, your pension is going to go to the nursing home, and Medicaid's going to pay the difference, and they're only going to let you keep $35 a month for personal needs allowance. $35 a month. You get toothpaste, toothbrush, buy your clothes, get your hair done, TV, telephone, mad money, $35 a month. That's why you want to put this money in the trust so that it can supplement what you need
So
if you're in
they
that
do
trust.
Social Security and.
Yes, correct.
Pension.
And pension, yes, that's right.
And when they look back, what are they looking at?
They're looking at every bank statement, every stock brokerage account, everything you have, and they are looking, number one, for large withdrawals. Right now, they're not looking at anything under $2,000, any withdrawal under $2,000. But that doesn't mean if they see a scheme, 1,000, they can go down to 10 cents if they want to. But right now, they're only looking at withdrawals of $2,000 or more, unless they have a suspicion there's some kind of a scheme to beat them. Okay, and they are also looking for deposits, because if it's not from your pension or it's not from your Social Security, where the hell are you getting this money? Maybe you got a secret bank account someplace you didn't tell them about. Okay, and of course they're going to do 1099 searches too, and the last thing you want to do is lie to these people. It's it's a federal offense. You don't want to do that. Okay,
Wasn't there a law that was, you could gift 10,000 to,
that's IRS, and I said that's up to
it's
14 because
14,
of
so that has
inflation.
nothing to do
Has
with-
nothing.
okay.
Separate agency, has nothing to do with Medicaid. Medicaid doesn't care about them. They don't care about Medicaid. Okay. Yes, ma'am.
Do any of the nursing homes refuse to take Medicaid?
Do any of the nursing homes refuse to take Medicaid? Okay, first of all, I will tell you that it is a fallacy that nursing homes that take Medicaid are crummy. Some of the best nursing homes in the state take Medicaid, and I can tell you, I think two of the best in northern New Jersey is the Christian Healthcare Center in Wyckoff and the Jewish Center in Rockley. And I've got lots of Christians in the Jewish Center and lots of Jewish clients in the Christian Center. And I happen to like the Jewish Center better because they only have private rooms. When you go on Medicaid, Medicaid only pays for semi-private. The Jewish Center only has private rooms, so even when you're on Medicaid, you got your own room. And I don't know about you, but I don't want some stranger in the corner moaning away, when I can have my own room, okay? But they both take Medicaid. The thing that you want to know is nobody wants a Medicaid patient. Why? Because they make less money on Medicaid. And the minute a nursing home takes you in as a Medicaid patient, they are now committed that the second you are eligible for Medicaid, they have to keep you on Medicaid for the rest of their lives. So what they want is key money. They want to see, I call it key money, it's turn the key, get you in the door. They call it spend down money. They want to see you got some money so you can pay full boat for a while, okay? Or there's some other bait. What did I say the bait was before? You go in because Medicare is paying, they're gonna make lots of money on Medicare. You don't want to go to a place that does rehab, but no long-term. Or the long-term they don't take Medicaid for. They only take Medicare because they will suck all your money down and then spit you out, okay? So what you want to do is you want to go to a nursing, and this is what happens, and I tell people all the time when they come in and say, Mom's had a stroke, she's at Valley Hospital. I say, any minute, you're going to get a call from the social worker staff saying, they're discharging Mom tomorrow. And so you better know where, and we're going to discharge her to XYZ place to get rehab. Well, you want to make sure that XYZ is a place that will also have long-term care, will take Medicaid when Mom is out of money. Otherwise, you're not sending her to XYZ. You got to line up with ABC that'll do that, okay? And so you have to be on the ball. We would send you to a bunch of places. We want you to window shop, see which places you like. We tell you which ones we like. And I will tell you, handling to get somebody into the place is just like handling for a used car. It all depends on how many empty beds they have at the moment, whether they'll take what's called a direct admit. A direct admit is someone who is going to be on Medicaid immediately, or how much they want you to pay. And of course, the better places have longer waiting lists. But they can't now discriminate. They just passed the law. They can't discriminate against people who don't have any money. So what the better places are saying now is it takes 6 months to get the PASS. PASS is the pre-admission screening, which you can get a lot faster, but Medicaid can take up to 6 months to give you a pass. So what the better places are saying is you got to be able to pay full boat for 6 months. That's how they're trying to get around the law. Okay, And of course, when you apply for the nursing home, one of the things they want to know is all your financial information. Okay? So, you know, you have to know the ropes.